Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and the decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions are those of the speaker.
Hello, and welcome to SCOTUScast. I'm your host, Kyle Hammerness, on behalf of the Faculty Division of the Federalist Society. We are here today to discuss Dewberry Group Incorporated versus Dewberry Engineers Incorporated, which was decided by the Supreme Court in a 9-0 decision on February 26, 2025. It is my honor to introduce our guest today, Professor Jake Linford. Professor Linford is the Loula, Fuller, and Dan Myers Professor and Associate Dean for Research at the Florida State University College of Law. He focuses his scholarship on trademarks, copyright, and contract law. He teaches trademarks and unfair competition, contracts, copyright, information privacy, and various IP and tech-related seminars. His scholarship empirically tests and theoretically reassesses key trademark and copyright doctrines and has been published in leading law reviews, including the Georgetown Law Review, Notre Dame Law Review, and Minnesota Law Review. And with that, I'd like to hand things over to Professor Linford.
Thank you, Kyle. I'm glad to be with you here today. So you brought me here to chat about the Dewberry case. This is Dewberry Engineering versus Dewberry Group, although I think when it went to the Supreme Court, the parties were flipped because Dewberry Group was the petitioner. All right, so here's the thing. Both of these companies, Dewberry and Dewberry, not confusing at all, we'll call the plaintiff, the party claiming trademark infringement, we'll call them engineers, that's Dewberry Engineers. We'll call the defendant Dewberry Group, or call them group. There was a settlement between those parties initially where the group agreed not to use trademarks in certain states that included the term Dewberry for real estate related goods and services. And then the group broke that settlement, started engaging in trademark infringement. So a district court in Virginia concluded, and then we get to the question of what's the remedy. And under Section 35A of the Lanham Act, this is 35 U.S.C. 1117A, the plaintiff can get defendant's profits. Now, here's the problem for the plaintiff in this case, and this is what went all the way to the Supreme Court. The defendant group had a bunch of different affiliated businesses that were organized into their own corporate entities. So they would be engaged in basically owners of different real estate interests using that Dewberry name. The central organization, or the one that was sued anyway, the defendant in the case, would handle human resources stuff, billing. All of the entities, group and all of the affiliates were owned by the same individual, John Dewberry, but John Dewberry wasn't a named plaintiff either. So just group. Group would provide services to these affiliates at a loss. The affiliates would get revenue for people paying for real estate services, rental income, etc. And each affiliate would keep its separate revenues and would pay group for the services group provided, but paid less than market value for those services. So group would lose money. Each of the affiliates would make money. Eventually, as it appears to me, the money was flowing back into John Dewberry's pockets. And John Dewberry would make up the difference, the losses that group suffered from its own pockets. But the problem for engineering, our plaintiff under the statute, is when they went to establish profits from Dewberry Group, the group didn't have any profits. They were able to show losses and no profits. Now, it's obvious what's going on here structurally. There's money coming in for trademark infringement to the individual affiliates that's ending up in John Dewberry's pockets. But the question is, what can you do about that? Because we have a principle under corporate law, you can divide a business into a separate corporate entity, and shareholders of that corporate entity can't be individually sued, generally speaking, for misbehavior of the corporate entity. And that might very well pertain to tort liability. There's a famous case that most corporations classes cover, a case called Walkowski. And in Walkowski, the problem is somebody's taxi cab hits a pedestrian and injures him. and the pedestrian sues, and the cab company has basically divided every 2 or 3 cabs into their own corporation. So there's a bunch of money that's ostensibly owned by one owner, or at least that's the claim of our injured tort plaintiff, but he can only get at the money that's in the pockets of these 2 cab companies or their insurance value, and it's not enough to cover his losses. And he tries to get at that money, and the court in New York tells him, well, you can't. Unless you can pierce the corporate veil, unless you can kind of get behind this corporate structure. The whole point of a corporate structure is to create kind of these individual entities that have their own individual liability, and we allow them to kind of gather in resources, gathering capital by allowing shareholders to buy in, provide money, take profits back out without necessarily taking the liability that comes with the company. So we have corporate structure on the one hand and trademark law on the other hand kind of bumping up against each other. And this trademark statute says that the plaintiff can get defendant's profits, but Dewberry Group doesn't have any profits. So what do? The district court is persuaded that it can reasonably assess the actual reality on the ground, which is to say, obviously these affiliates are making income, they are trademark infringers, and we can take the profits not only of Group, but also of the affiliates. Now, Group didn't, what you can do as the defendant in a case like this is you can enter into the record expenses, profits that aren't attributable to the trademark infringement, et cetera, and you can get a discount against the net profits or the gross profits. Group doesn't do that because, of course, Group's trying to argue that you can't get at the affiliates, or you shouldn't be able to get at the affiliates. So what we have is the district court basically applying a 20% discount across the board. So the damages award effectively gives engineers, our plaintiffs, 80% of the profits from the relative period for each of the affiliates. Dewberry Group appeals. Fourth Circuit affirms the district court and affirms the district court's approach to damages, effectively saying, look, disgorgement of profits is an equitable remedy. And we're not going to require, it was not necessary, I guess the Fourth Circuit says, to require piercing the corporate veil. The district court can consider the revenue of the entities under common ownership, calculate the true financial gain from the infringing activities, and that equitable power, the scope of equitable discretion of a district court is broad enough to look reasonably at what's going on. And this isn't a crazy way to see the world. Let me give you an example. So imagine I've decided I want to go into the soda business. And I've decided that my winning move is to imitate the trademark of a big player in the soda industry here, Coca-Cola. And so I'm going to launch a Coke. I'm going to call it Coke Ford. You know, that's the last part of my last name. I'm going to have Coke Ford. I'm going to have Coke Ford Zero. I'm going to have Diet Coke Ford. I'm going to have Vanilla Coke Ford. I'm going to have Cherry Coke Ford. And I'm going to divide my sales of Coke into a separate corporation. I'm going to have one corporate entity that just sells Coke Ford, another corporate entity that just sells Coke Ford Zero, another corporate entity that just sells Diet Coke Ford. I'm going to take all the losses to my central organization, another corporate entity. We'll call it Coke Ford Company. And I'm going to leave all the profits with the individual entities. Now, you and I both know exactly what I'm doing here. And that there's revenue as the sole shareholder of Coke Ford and Coke Ford Zero and Diet Coke Ford. That money's going to be all the way back in my pocket. And to the extent I'm making up the difference from my core entity for each of the affiliates in the services I provide, that's probably the money coming from the affiliates going back to the core. And so if we're willing to look at the reality on the ground, the result from the district court, the result from the Court of Appeals doesn't seem crazy. The problem is we've got corporate law and we've got this commitment to treating individual corporate entities as individual and insulating them from one another with regards to liability. And so that's the case that goes up to the Supreme Court. The district court says effectively, the defendant here, Group, says the question before the court, the question that the court should answer is whether this award of defendant's profits can include disgorging the distinct profits of legally separate non-party corporate affiliates. In other words, really focusing on the corporate structure and how we tend to treat these things under corporate law. Of course, the plaintiff says their question is really, does the district court have discretion? It's that equitable discretion to use financial statements of non-arm's length affiliates. In other words, these things are all tied pretty closely, Your Honors, to adjust a disgorgement award in favor of counting up the profits where the infringer has claimed $0 in profit. So the plaintiff's hopeful structure of the question was all about the economic realities. And like you said, the Supreme Court decided 9-0, and they decide 9-0 in favor of Dewberry Group, in favor of the petitioner, the defendant, the loser below, saying when the statute says defendant's profits, we really do mean defendant's profits. And if the only defendant against whom a claim was brought is this defendant with zero profits, well, the district court can't just assume or conclude based on its view of the economic realities without some sort of analysis that it can get to the affiliates. That's the simple holding there. Now, that might sound dispositive against engineers. It's not necessarily. Engineers has some options on remand, potentially. The court actually hints at what might be a proper approach. Now, the statute I mentioned, it gives the plaintiff access to defendant's profits as a measure of damages. It also says, and engineers, our plaintiff, wanted to argue that the district court and the Court of Appeals effectively applied this provision. It also says that if the court shall find the amount of recovery based on profits is either inadequate or excessive, the court may in its discretion enter judgment for a sum such as the court shall find just according to the circumstances of the case. In other words, if the damages award is too low, or if the damages award is too high based on profits, the court can adjust and has some equitable discretion to adjust. Now, the district court does not say it's relying on this just sum provision and doesn't make any analysis of the adjustments it's making because of the just sum provision. It just says, I'm looking past this corporate screen and I'm counting the damages of each of the affiliates. And here's what the court says that hints at the potential proper approach. Maybe this works for Dewberry Engineers on remand. Ideally, it could work for another plaintiff in a similar situation. The district court did not rely on the just sum provision or suggest it was departing up from defendant's reported profits to reflect the company's true gains. And perhaps if it had, this seems to be the hint of the court, that might have been sufficient to get us past this question of corporate structure. Now, Dewberry Engineers, our plaintiff below, did not they didn't sue John Dewberry directly. They didn't sue any of the affiliates directly. Had they done so, they avoid this problem. They also didn't try another move, which is potential, which the Supreme Court said, look, we're not ruling on this move either. There are a couple of ways you can get behind the corporate entity. One of them we call piercing the corporate veil. Another way to phrase this is we think that the individual corporations are all alter egos for one another, or they're agents for one another. In other words, they are closely connected. And in both cases, we ask questions that are like the questions we've been talking about here, right? In the alter ego case, generally a plaintiff has to prove that there's a parent company that dominates and controls the subsidiary to the extent that the subsidiary is just doing business for the parent and that they don't really exist as separate legal entities. And there will be an injustice or a wrong to the plaintiff that will happen if we don't pierce the veil, right? And factors that we might consider in cases like this, well, is one corporation adequately capitalized? Is there an overlap in ownership or personnel? Are they sharing common office space? Is the business discretion, how much business discretion does the allegedly dominant corporation have? Are they engaging in arm's length transactions with one another? Are they too close? Does the corporation treat the independent as a profit center? Are they paying each other's debts, etc.? And what I think, had you applied this standard in the way it could reasonably be applied, I think you'd reach it. Now, there's a problem for engineering, which is to say, in many jurisdictions, courts are very skeptical of veil piercing. Although there are veil piercing cases that have been successful, and these are the sorts of questions we ask in a successful veil piercing case. So the Supreme Court says, veil piercing is potentially an option. We're not ruling on it one way or another. We're not ruling on whether Dewberry Engineers on remand could argue for this just sum application and use that as a justification. There is a potential forfeiture problem. They didn't do it below. Potentially, they didn't preserve that argument below, and therefore the district court can't reach it again. There is also in the future for similarly situated plaintiffs the option of you implead all of the various you bring in all the various defendants on the individual corporations. Now that's more costly. In a case of trademark infringement, you can sometimes, under this same statutory provision, get attorneys' costs and fees. If you can get costs, you might be able to pick up the additional revenues for having to sue the multiple entities, but you're not guaranteed costs, and the Supreme Court's jurisprudence on this point requires a case that is an unusual or outstanding case. And whether this would amount to that sort of outstanding, or I should say exceptional case, is a live question. Justice Sotomayor had a concurrence, and her concurrence effectively it concedes the point that the district court's analysis was too shallow, but the trademark law should allow for looking at the reality of the situation. And that was more or less the argument by the government. The government was invited to brief the case, and the government's brief effectively said the same thing. We want to take seriously the actual structure of the entity. Courts are not required to take whatever accounting tricks or tax structures that a defendant presents as the reality of the situation when deciding a case like this. And therefore, we can look at those realities. But the government did argue for remand in this case because the district court hadn't worked through the analysis. And so what we'll see on remand is what the district court thinks its remit is as far as working through this analysis and potentially granting damages under the just sum provision, or potentially inviting engineers to engage in the veil piercing that it didn't think it had to engage in, or argued that it didn't have to engage in the first time around.
Right. Well, thank you for going over the case. I'm really providing a great detailed overview. You mentioned that that engineers could have brought in all of the affiliates.
Plausibly,
yes. Would that still work if those affiliates weren't violating trademark law? Well, like if they instead of being, as you were saying, Cokeford and Cherry Cokeford and all that, it was, I don't just pick another name that it doesn't have Coke, right? That doesn't have Coke in it. Would that then be a problem because they're not then violating the trademark? How can then you get to them in that way? Because then you may not even have standing against them.
Yes. Now, my understanding of this case is that each of the affiliates for which profits were counted were using the Dewberry mark. But you're absolutely right. This is one of the difficulties. If you're not using the Dewberry mark, then those affiliates shouldn't be brought in, unless they're using a mark that's similar enough but different. And at that point, you've got some messes here where it may be plaintiffs A, B, and C are using more or less the exact mark, or sorry, defendants A, B, and C are using the exact mark. Defendants E and F aren't, but potentially close enough. The analysis would be different. Defendant G isn't using the mark at all. Right, and we should treat those different things as different. This is one of the points that was raised in the brief, on my brief with Professors Beatty and Schuster. One of the difficulties, it might be the case that, say, for example, the core entity is engaged in willful infringement. That's what was determined by the district court. Now, are each of the affiliates engaged in willful infringement? I'm not sure there's another person there. If we can say each of the affiliates is run by John Dewberry, then perhaps yes. If we can't say that each of the affiliates is run directly by John Dewberry, then you may not have that same willfulness, and that would change potentially the calculation. Willful defendants are sometimes on the hook for more damages under the statute.
Right. I guess a little bit more broad than my specific example, what do you see as the real consequences, just kind of broad 30,000-foot view on trademark law after this case?
So there's a danger, and the government brief hit on this, and our brief hit on this. There's a danger that if you ignore the realities on the ground, you are insulating firms that shouldn't be insulated from liability. Lots of firms structure things exactly the way that Dewberry did, exactly the way that my Cokeford example would, which is to say, you've got a bunch of affiliate organizations, perhaps separate entities, but benefiting from the use of the trademark, and the value, the profit derived from the trademark may very well spill over beyond the bounds of a singular corporate entity. And being too formalistic about corporate entities potentially undercounts the harm that the mechanism Congress gives us to count this harm, which is the defendant's profits. On the other hand, if you are persuaded, like lots of folks are, that one of the keys to American success is corporate structure and the ability of corporate entities to bring in capital by insulating those who buy into the corporation from direct liability, being too casual about how we pierce those corporate barriers can have effects that run beyond trademark law and are potentially distortive of a kind of a foundational element of the American economic system. So I think plaintiffs situated like Dewberry are going to have to think more carefully, are probably going to have to do more due diligence. It's going to increase litigation costs on them to some extent, to make sure we don't have a situation, to make sure they're not facing a situation where a defendant has kind of structured its revenues in such a way that you can't get at the profits. Because frankly, you can get profits or you can get plaintiff's damages. It's much easier to count profits. It's much harder to count damages. Damages are rarely granted in trademark cases, other than in places where you've got like a counterfeiting claim or some other multiplier, statutory damage for willful infringement, etc. Injunctions are the most likely remedy for a plaintiff, and then disgorgement of profits much more likely than damages. So plaintiffs are going to have to figure out a way to account for this. Now, this may be a rare case, and if it's a sufficiently rare case, it won't make much difference at all. I suspect that there will be careful and clever attorneys who will read these cases and see a loophole and then advise their clients who might be flying close to the sun in Greek metaphor terms with regard to trademark infringement. Well, let's insulate the core business from potential infringement of subsidiary businesses and see if we can structure this in a way that we can take a Dewberry Group style advantage that might save some damages on the back end.
All right. Well, thank you so much for really just providing a great summary of this case and its potential consequences. And really, thank you so much for joining us.
Well, thank you, Kyle. Really appreciate it.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is essential to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.